You are standing in a telephone booth. It is 1965, and the glass door has just clicked shut behind you. Outside, the traffic of Los Angeles moves in soft, distant hums. Inside, the booth smells faintly of cigarette smoke and metal. The phone is cold against your ear. You drop a dime into the slot, and somewhere in the machinery, a connection is made. You believe, in this moment, that you are alone. You believe that the words you are about to speak will travel through the wire and arrive only where you intend them to go. You believe that the glass around you, thin as it is, marks a boundary, that the door you closed means something, that privacy, in this small and temporary space, is yours. But outside, on the street, two men are listening. They are agents of the Federal Bureau of Investigation. They have attached a device to the exterior of the phone booth, a listening device, small and unobtrusive. It does not penetrate the glass. It does not enter the booth. It simply listens to what you say from the outside and records it. You do not see them. You do not know they are there. And when your case comes to trial, the government will argue that because they did not physically intrude into the booth, because they did not open the door or break the glass, they did not violate your rights. Because, they will say, you had no reasonable expectation of privacy. This is where the story begins. Before there was a reasonable expectation of privacy, there was only trespass. For more than a century, the Fourth Amendment to the United States Constitution was understood through the lens of property. The amendment read, as it still does, that people had the right to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. And for most of American history, courts interpreted this to mean that the government could not physically invade your property without a warrant. If they entered your home, that was a search. If they opened your desk, that was a search. If they took your letters, that was a seizure. The violation was always tied to a place, to a thing you owned, to a boundary that had been crossed. You are standing now in a courtroom in 1928 in Washington, D.C. The room is formal, wood-paneled, filled with the low murmur of attorneys and clerks. At the center of the case is a man named Roy Olmsted, a former police officer turned bootlegger during Prohibition. Olmsted ran a sophisticated smuggling operation, bringing Canadian whiskey into Seattle by boat and distributing it across the Pacific Northwest. The government wanted to catch him, so they tapped his telephone lines. They did not enter his home. They did not break into his office. They placed wiretaps on the telephone wires outside his property, in the basement of his building and along the streets. They listened to his conversations for months. They gathered evidence. And when the case went to trial, Olmsted was convicted. But Olmsted argued that the wiretapping violated his Fourth Amendment rights. He said the government had searched him without a warrant. The Supreme Court disagreed. Chief Justice William Howard Taft, writing for the majority in Olmsted v. United States, held that there was no Fourth Amendment violation because there had been no physical trespass. The wires were tapped outside Olmsted's property. The government agents never entered his home. The Fourth Amendment, Taft wrote, protected only against physical invasions of tangible property. A conversation, he said, was not a tangible thing. A telephone line was not a house or a paper or an effect. The amendment itself shows that the search is to be of material things, the person, the house, his papers, or his effects, Taft wrote. The language of the amendment cannot be extended and expanded to include telephone wires reaching to the whole world from the defendant's house or office. The wiretap, in other words, was legal, because it did not cross a threshold. But even then, in 1928, there was a voice of dissent. Justice Louis Brandeis sat in that same courtroom listening to the arguments, and he understood something that the majority did not. He understood that the world was changing, that technology was changing, that the Fourth Amendment could not remain frozen in the age of physical trespass if it was to protect anything meaningful at all. Brandeis wrote a dissent that would become one of the most famous in American legal history. The makers of our Constitution, he wrote, undertook to secure conditions favorable to the pursuit of happiness. They recognized the significance of man's spiritual nature, of his feelings, and of his intellect. They knew that only a part of the pain, pleasure, and satisfactions of life are to be found in material things. They sought to protect Americans in their beliefs, their thoughts, their emotions, and their sensations. They conferred, as against the government, the right to be let alone, the most comprehensive of rights, and the right most valued by civilized men. The right to be let alone. Brandeis saw what was coming. He saw that as technology advanced, the government would find new ways to surveil citizens without ever setting foot on their property. Wiretaps, microphones, cameras, devices that could listen and watch from a distance, that could pierce the walls of privacy without ever crossing a threshold. And he warned that if the Fourth Amendment was interpreted only as a protection against physical trespass, it would become meaningless. But in 1928, the majority did not listen. The property-based test remained. For nearly 40 years, the Fourth Amendment was understood through the lens of Olmsted. If the government did not physically intrude, there was no search. And so, in telephone booths and on street corners, in letters and in conversations, people spoke and acted with the belief that they were private, while the government listened. Until one man, in one telephone booth, changed everything. You are standing in a federal courtroom in Los Angeles in 1967. The case is United States versus Charles Katz, and it has traveled all the way to the Supreme Court. Katz himself is not a violent man, not a murderer or a thief in any conventional sense. He is a gambler. He places bets on college basketball games, transmitting wagering information across state lines using public telephones. The FBI, suspecting illegal gambling activity, placed listening devices on the outside of several public telephone booths that Katz used regularly. They recorded his end of the conversations. They did not obtain a warrant. They did not enter the booth. They simply listened, from the outside, and used the recordings as evidence to convict him. Katz's attorneys argued that the surveillance violated the Fourth Amendment. The government argued, citing Olmsted, that there was no trespass and therefore no search. The lower courts sided with the government. The conviction stood. But the case went up to the Supreme Court, and there something shifted. Justice Potter Stewart delivered the opinion of the court, and in it he did something remarkable. He abandoned the property-based test that had governed Fourth Amendment law for nearly 2 centuries. The Fourth Amendment protects people, not places, Stewart wrote. You can feel the weight of that sentence, the way it opens a door that had been closed for so long. The Fourth Amendment, Stewart said, was not about walls or doors or physical boundaries. It was about people. It was about whether a person, in any given situation, had a right to expect privacy. And in a telephone booth, with the door closed, Charles Katz had that right. What a person knowingly exposes to the public, even in his own home or office, is not a subject of Fourth Amendment protection, Stewart wrote. But what he seeks to preserve as private, even in an area accessible to the public, may be constitutionally protected. Katz had closed the door of the booth. He had paid for the call. He had spoken in a way that assumed his words were private. He had, in Stewart's words, exhibited an actual expectation of privacy. And society, Stewart said, was prepared to recognize that expectation as reasonable. The FBI's surveillance, therefore, was a search, and because they had conducted it without a warrant, it violated the Fourth Amendment. But it was Justice John Marshall Harlan, in his concurring opinion, who gave the doctrine its lasting form. Harlan distilled the test into two prongs. First, he wrote, a person must have exhibited an actual subjective expectation of privacy. Second, that expectation must be one that society is prepared to recognize as reasonable. This became known as the Katz test, or the reasonable expectation of privacy standard. And with those words, the law shifted. The Fourth Amendment was no longer about property lines, it was about privacy, about what people believed was theirs to keep and what society agreed they could keep. But as you stand there in that courtroom, listening to the decision, you might begin to wonder, what does it mean to have a reasonable expectation of privacy? Who decides what is reasonable? And as technology continues to change, as new ways of watching and listening emerge, how will this test hold? These are the questions that courts would spend the next 50 years trying to answer. You are standing on a suburban street in Laguna Beach, California. It is early morning, before dawn, and the air is cool and still. The streetlights cast long shadows across the pavement. At the curb, in front of a modest home, sit two black plastic garbage bags. Inside those bags are the remnants of daily life, food wrappers, old newspapers, junk mail. But also, mixed among the refuse, are traces of something else. Small plastic bags, residue, scraps of paper with names and numbers. Evidence, the police believe, of drug trafficking. The police do not have a warrant. They do not knock on the door. They simply wait for the garbage truck to arrive, and when it does, they ask the driver to hand over the bags instead of taking them to the landfill. The driver complies. The police search the bags. They find what they are looking for. They use that evidence to obtain a warrant. They search the home. They find more drugs. Billy Greenwood is arrested and charged with narcotics offenses. At trial, Greenwood's attorneys argue that the search of his garbage violated the Fourth Amendment. They say that even though the bags were left at the curb, Greenwood had a reasonable expectation of privacy in their contents. The case reaches the Supreme Court in 1988. Justice Byron White writes the opinion, and he holds that Greenwood had no reasonable expectation of privacy in the garbage he left for collection at the curb. Why? Because, White writes, it is common knowledge that garbage left for collection is readily accessible to animals, children, scavengers, snoops, and others. Greenwood exposed his garbage to the public. He placed it outside his home, in an area where anyone could take it. He could not reasonably expect that it would remain private. It is common knowledge, White wrote, that plastic garbage bags left on or at the side of a public street are readily accessible to animals, children, scavengers, snoops, and other members of the public. Society, in other words, does not recognize a person's claim to privacy in their trash once it is left for collection. The expectation is not reasonable, and so the search was lawful. But you stand there, reading the opinion, and you might pause. You might think of the things you have thrown away. Old bills with account numbers, medical prescriptions, personal letters. The detritus of your private life exposed, now, to anyone who cares to look. This is the edge of the doctrine. the place where privacy ends. You are standing outside a triplex in Florence, Oregon, on a cold January night in 1992. The building is unremarkable. Tan siding, small windows, a gravel driveway. Inside one of the units lives a man named Danny Kylo. The police suspect Kylo is growing marijuana indoors, using high-intensity heat lamps. But they do not have enough evidence for a warrant, so they try something new. From a car parked across the street, an agent aims a thermal imaging device at Kylo's home. The device detects infrared radiation, heat, emanating from the building. It does not see through walls. It does not reveal what is inside. It simply measures the heat on the surface of the home. The scan shows that Kylo's garage and one wall of his home are significantly warmer than the rest of the building and the neighboring units. The agent concludes that Kylo is using heat lamps. They use the thermal scan, along with other evidence, to obtain a warrant. They search the home. They find more than 100 marijuana plants. Kylo is arrested. At trial, Kylo's attorneys argue that the thermal imaging was a search under the Fourth Amendment and that it was conducted without a warrant. The government argues that it was not a search at all. The device, they say, only measured heat escaping from the home, heat that was already exposed to the public. No trespass, no intrusion, no search. The case reaches the Supreme Court in 2001. Justice Antonin Scalia writes the opinion, and he holds that the use of the thermal imaging device was a search. Why? Because the device allowed the government to explore details of the home that would previously have been unknowable without physical intrusion. The home, Scalia writes, is the most protected space under the Fourth Amendment. And when the government uses technology to gather information about the interior of a home, information that could not be obtained through ordinary observation, it constitutes a search. Where, as here, the government uses a device that is not in general public use to explore details of the home that would previously have been unknowable without physical intrusion, the surveillance is a search and is presumptively unreasonable without a warrant, Scalia wrote. This is a different kind of reasoning. It is not about whether Kylo had a subjective expectation of privacy in the heat escaping from his home. It is about the sanctity of the home itself, and about the principle that the government should not be able to use advanced technology to peer inside without a warrant. Kylo stands as a bulwark, a reminder that the Fourth Amendment must adapt to technology, that it must protect not just against physical intrusion, but against technological surveillance that reveals what the eye alone could never see. But even here, the limits are unclear. What if the technology becomes common? What if thermal imaging becomes as ordinary as binoculars? Does the expectation of privacy shrink as technology spreads? These questions linger. You are standing in a courtroom in Washington, D.C. in 2012. The case before the Supreme Court is United States versus Jones, and it involves a man suspected of drug trafficking. The police, suspecting Antoine Jones of narcotics activity, obtained a warrant to place a GPS tracking device on his vehicle. But the warrant specified that the device had to be installed within 10 days and within the District of Columbia. The police installed it on the 11th day in Maryland. For the next 28 days, the device transmitted Jones's location to the police every time the car moved. More than 2,000 pages of data were collected, mapping his every movement, every trip, every stop. The data was used to build a case against him. Jones was convicted. His attorneys argued that the GPS tracking was a search under the Fourth Amendment, conducted without a valid warrant. The government argued that Jones had no reasonable expectation of privacy in his movements on public roads. After all, anyone could have followed him. Anyone could have observed where he went. The Supreme Court agreed that the tracking was a search, but the reasoning split. Justice Scalia, writing for the majority, took a narrow, property-based approach. He held that the installation of the GPS device on Jones's car was a physical trespass. The government had placed something on his property to gather information. That, Scalia said, was a search under the original, pre-Katz understanding of the Fourth Amendment. But Justice Samuel Alito, in a concurring opinion, went further. He said that even if there had been no trespass, even if the government had tracked Jones using cell tower data or satellites, it still would have been a search. Why? Because long-term, continuous surveillance of a person's movements reveals an intimate picture of their life. It reveals patterns, habits, relationships, beliefs. It reveals things that short-term observation never could. And society, Alito argued, is not prepared to recognize as reasonable the expectation that the government can monitor your every movement for weeks on end. This is a new dimension of the doctrine. Not just whether you expose something to the public in a single moment, but whether the aggregation of data over time creates a different kind of invasion. Justice Sonia Sotomayor, in her own concurrence, pushed even further. She warned that in the digital age, people leave traces of themselves everywhere. Every cell phone ping, every credit card swipe, every internet search. And if the government can access all of that data without a warrant, simply because it is technically exposed to third parties, then the Fourth Amendment may become an empty promise. I would ask whether people reasonably expect that their movements will be recorded and aggregated in a manner that enables the government to ascertain, more or less at will, their political and religious beliefs, sexual habits, and so on, Sotomayor wrote. She was pointing toward a future that had not yet fully arrived, but that was coming fast. You are standing in a courtroom in 2018. The case is Carpenter versus United States, and it is about a man named Timothy Carpenter, convicted of armed robbery. The police, investigating a series of robberies in Michigan and Ohio, obtained Carpenter's cell phone records from his wireless carriers. Not the content of his calls or texts, but the cell site location information, CSLI, that showed which cell towers his phone connected to every time it was used. This data, collected over 127 days, created a detailed map of Carpenter's movements. It placed him near the scene of several robberies at the times they occurred. The data was powerful evidence, and it was used to convict him. Carpenter's attorneys argued that obtaining this data without a warrant violated the Fourth Amendment. The government argued that Carpenter had no reasonable expectation of privacy in the records because he had voluntarily shared his location information with the cell phone companies. Under a doctrine called the third-party doctrine, established in cases like Smith v. Maryland and United States v. Miller, information voluntarily given to third parties loses Fourth Amendment protection. But Chief Justice John Roberts, writing for a narrow majority, held that the third-party doctrine did not apply to CSLI. This data, Roberts said, was different. It was not voluntarily shared in any meaningful sense. People do not carry cell phones to share their location with the government. They carry them to communicate, to navigate, to live their lives in the modern world. And the data generated by those phones is comprehensive, detailed, and deeply revealing. It tracks not just a single trip, but the whole of a person's movements over time. It reveals their habits, their associations, their routines. It can place them in a therapist's office, at a political rally, in a place of worship. A cell phone faithfully follows its owner beyond public thoroughfares and into private residences, doctors' offices, political headquarters, and other potentially revealing locales, Roberts wrote. Accordingly, when the government tracks the location of a cell phone, it achieves near-perfect surveillance, as if it had attached an ankle monitor to the phone's user. The court held that accessing this data is a search under the Fourth Amendment, and because the government obtained it without a warrant, the search was unreasonable. Carpenter is a landmark. It signals that the reasonable expectation of privacy doctrine can stretch to cover the digital traces we leave behind, even when those traces are held by third parties. It recognizes that the world has changed, and the Fourth Amendment must change with it. But it is also narrow. The court was careful to limit its holding to CSLI. It left open questions about other kinds of digital data, other forms of surveillance. The edges of the doctrine remain uncertain. You are sitting in your home, late at night, scrolling through your phone. You check your email, you browse a news site, you search for a recipe, you send a message to a friend, you look up directions to a restaurant, you watch a video, you check the weather. Each of these actions generates data: your location, your search history, your contacts, your habits, your interests. This data is collected by companies, stored on servers, analyzed by algorithms. Some of it is sold, some of it is shared, some of it sits, waiting. And under current law, much of it is not protected by the Fourth Amendment. Because you shared it with a third party, because you agreed to the terms of service, because you clicked accept. This is the frontier of the reasonable expectation of privacy doctrine, the place where it meets the digital age and struggles to keep up. The Supreme Court has said in Carpenter that some digital data is protected, but the boundaries are unclear. Is your email protected? Your browsing history? Your smart home device recordings? Your DNA uploaded to a genealogy website? These questions are being litigated now in courtrooms across the country, and the answers will shape the future of privacy in America. The phrase reasonable expectation of privacy is often misunderstood. People hear it and think it means that if you expect something to be private, it is protected. But that is not quite right. The test has two parts. You must have an actual subjective expectation of privacy. But that expectation must also be one that society is prepared to recognize as reasonable. And society's view changes. In 1965, people expected that a closed telephone booth was private. In 1988, the Supreme Court said that garbage left at the curb was not. In 2001, they said that the interior of a home, even the heat emanating from it, was. In 2012, they said that long-term GPS tracking was a search. In 2018, they said that cell phone location data was protected. But in between, in the spaces where the court has not spoken, the doctrine bends and shifts. Lower courts disagree. Police practices vary. And people, going about their lives, often do not know what is private and what is not. Consider the case of Riley versus California, decided in 2014. Police arrested David Riley during a traffic stop and searched his cell phone without a warrant. They found photos and videos that linked him to a gang-related shooting. The Supreme Court held, unanimously, that searching a cell phone is a search under the Fourth Amendment, and that it generally requires a warrant. Chief Justice Roberts, writing for the court, noted that cell phones are different from physical objects. They contain vast amounts of personal information: messages, photos, emails, browsing history, location data. Searching a cell phone, Roberts wrote, is not like searching a wallet or a pocket. It is like searching an entire life. Modern cell phones are not just another technological convenience, Roberts wrote. With all they contain and all they may reveal, they hold for many Americans the privacies of life. This is the doctrine at its best, adapting to new realities, recognizing that technology changes what privacy means and protecting it accordingly. But there are limits. In 2016, the FBI sought to compel Apple to unlock the iPhone of one of the shooters in the San Bernardino terrorist attack. Apple refused, arguing that creating a backdoor into the phone would compromise the security and privacy of all iPhone users. The case became a flashpoint in the debate over privacy versus security, encryption versus access. The FBI eventually found another way to unlock the phone, and the case was dropped. But the questions remain. If the government cannot search a phone without a warrant, can it compel a company to help it break in? Can it require companies to design their products in ways that make surveillance easier? These are not questions about reasonable expectations of privacy. They are questions about power, about technology, about the balance between liberty and security in a digital age. And they are questions the law has not yet fully answered. You are in a courtroom in Los Angeles. In 1995, the trial of Orenthal James Simpson, O.J. Simpson, is nearing its end. The case has been watched by millions, dissected by legal analysts, turned into a spectacle. But amid the drama, there is a quieter moment, one that touches on privacy. During the investigation, police searched Simpson's home and his vehicle. They collected evidence: blood, fibers, a glove. Some of this evidence was collected with a warrant, some was not. Simpson's defense attorneys argued that some of the searches violated the Fourth Amendment. They sought to have certain evidence suppressed. The prosecution argued that the searches were lawful, that exigent circumstances or consent or plain view justified them. The judge, Lance Ito, ruled on each piece of evidence individually, weighing the circumstances, the expectations, the reasonableness. Much of the evidence was admitted. Simpson was acquitted. But the case illustrates the way the reasonable expectation of privacy doctrine works in practice. It is not a bright line. It is a series of judgments made case by case, balancing privacy against the needs of law enforcement, individual rights against public safety. And it is shaped, always, by the specifics. Where were you standing? What did you expose? What did you seek to keep private? And would society agree that you had the right to keep it? These questions do not have easy answers. You are standing now, back in that telephone booth. The door is closed, the phone is in your hand. You are about to speak, and you believe, in this moment, that you are alone. But you cannot be certain, because privacy, it turns out, is not a thing you can hold or a line you can draw. It is an expectation, a hope, a claim you make that society may or may not recognize as reasonable. And what is reasonable changes. It changes with technology, it changes with culture, it changes with the courts as they interpret and reinterpret the Fourth Amendment in light of new realities. The reasonable expectation of privacy doctrine, born in Katz versus United States, was an attempt to make the Fourth Amendment flexible, to allow it to protect privacy even as the world changed. And in many ways, it has succeeded. It has adapted to thermal imaging and GPS trackers and cell phone data. It has recognized that the home, the person, the phone, These are things worth protecting. But it is also a doctrine of limits. It depends on society's judgment, and society's judgment can be fickle. It can shift with fear, with convenience, with the slow erosion of norms. What once seemed private can come to seem public. What once required a warrant can come to seem routine. And so, as you stand in that telephone booth, or sit in your home, or walk down the street with your phone in your pocket, you might ask yourself, what do I expect to be private, and would society agree? These are not abstract questions. They are the questions that shape whether the government can listen to your calls, read your emails, track your movements, search your data. They are the questions that define what it means in this time, in this place, to be let alone. And they are questions that each generation must answer anew. Because the reasonable expectation of privacy is not a fixed thing, written once and carried forward unchanged. It is a conversation between the courts and the people, between privacy and security, between the world as it is and the world as we believe it should be. And that conversation, quiet as it is one of the most important in American law. So you stand there in the telephone booth or in your home or wherever you are, and you speak, and you hope that what you say, what you do, what you keep to yourself will remain yours. But you cannot be certain, because privacy, in the end, is not a guarantee. It is a claim, a right, an expectation. And whether it is reasonable depends on all of us.